We're going to call the second panel to order. And again, I'm going to remind everybody, since we just came back from a break, if you have a cell phone, please make sure that it's off. Our second panel is Views on E-Discovery and Technology. Our panel participants, in not the order you're seated, are Russell Aoki, Coordinating Discovery Attorney, Sean Broderick, National Litigation Support Administrator, Donna Lee Elm, Federal Public Defender from the Middle District of Florida, Douglas Mitchell, CJA Panel Attorney from the District of Nevada. So that being said, again, let me say thank you very much for being here. We'd like you to make a brief opening statement. We got your submissions. We'll have the opportunity to ask you questions, but we would like you to make a brief opening statement, and then we will begin our questioning. So we'll start with you, Ms. Elm.
Thank you very much, Your Honor, and this very important and long overdue committee. Thank you for inviting us. Thank you for putting us together and listening to us. We have some very closely related issues we'd like to talk to you about. I am not only the federal defender from Middle Florida, but I am the chair of the Defender Automation Working Group, and I'm also the Defender member on the Joint Electronic and Technology Working Group with DOJ. So I do have a fair amount of involvement in IT, although I must confess that I am a dinosaur. There's been a growing awareness, and Mr. Broderick brought this out very well in his, that DOJ is flying ahead of us in terms of their technology, that they and private firms are well in advance. And if we are going to be providing the same type of representation you can get if you paid for it, defenders are way behind, and CJA are left even further behind. With recently, when I started chairing DOG, we looked at it and said we need to try and move Defender IT ahead. We need to try and get us more into the ITA age here, and we pushed to try and get a lot of things done. At the same time, there was the reorganization. I have to tell you that my thought was, okay, they've moved the administration of our IT over into another group. Shouldn't be a big deal. We just have to be a little schizophrenic. And it turned out to be slowly dawning on us that it was a major and problematic shift. And it's what Mr. Kalar said, I think, is true in his written testimony. It's a structural problem. There's a structural problem that we're dealing with here. In my written testimony, I explained what the problem was. What I propose to do now is say that that really begs the question of what would an effective structure for Defender IT be, and how would that work in the proposal of how we try and set this up. In the end, obviously, I think the advisory groups have to be deeply involved into how that's done. This is not something that has come through the advisory groups yet, but I want to propose, from our work that we've been doing on this for a while and the talk we've had, what this may look like and may work as. And that would be this. We need to start with central leadership. As I explained in my testimony, we had central leadership in DSO. We had Defender IT there. That was removed and moved over to CMSO. We had no one to fill the void. We have an IT liaison who is a lovely gentleman, but he is an IT liaison. He is not a leader. He is not a manager. He does not have enough experience with administration to know where he needs to go for what he needs to do. Lovely guy doing his job, but it's not the job we need to have done. When that was removed from DSO, we did get a person in CMSO, which is case management, and I'm going to presume you know these acronyms. If you don't, just so.
Thank you.
Okay, here we go.
We're so inundated with acronyms. I'd really appreciate it if all of you would try not to use them.
All right.
Tell us what you're talking about.
Okay. Defender Services,
That one I know.
okay, DSO. CMSO, Case Management Services Office. Now, CMSO is one of the new AOIT branches. There's two of them. We really just deal with one. And what they did when they did the reorganization is they took our IT, as you may recall, to move it over into CMSO. We protested and then got to keep all of our Defender client information separate, but administration went over there. So we have our Defender client and a lot of our programs over here. We have a branch of the AO's IT over here with some of the administration. It gets, I tried to explain it in my written testimony. It's pretty crazy as to how many different places we're going for who's in charge of what. In any event, it was removed from CMSO, and so the person removed to CMSO. The person in CMSO who's in charge of Defender IT, though, really isn't in charge of Defender IT. She's just to do administration of it. And then we have no one really managing it. What's happened is that people have moved in to fill the void. DOG has moved in often to fill the void. In fact, on things like trying to select personnel for NITOD, and in trying to pick whether we're going to do a little minor change onto one particular program. And DOG, which is an advisory group, has been put into that position. The head defender of Texas Western has been pushed into that position. DSAG, which is the Defender Services Advisory Group, the top, probably our top Defender Services group, Defender group, has been pushed into that position. And of course, CMSO has been trying to take some of that position. It has left us in an untenable place, and what we need, and what I recently went to talk to them about, was a strong leadership management position. We need that once again, and with someone who's a good manager, a good communicator, understands administration of an agency, but someone who, unlike CMSO, none to their fault, has our mission, great quality representation, and understands that we are here to take care of clients. We are a law firm. This is not the business of the AO. Also, if we were to get that person in that position, there would have to be several positions reporting directly. I would suggest NITOD should be reporting to this person. NITOD is our national IT, the center where they actually have all the servers, they work with all the emails, they do the troubleshooting, they set things up. They're our national IT. They are in Texas Western and are under Maureen Franco. That person, right now, that person is reporting to God and everybody. There are so many different persons that person has to report to, it would be very hard to follow. I think that if we had one central strong leader, it could be reporting there. We need a data specialist, and there's been talk of getting someone into that position, but it became very clear to us with the work measurement study that we have not paid enough attention to how important our data is, and I'm not talking client data, I'm talking our numbers, our time, the things that will determine what our budgets are, what our staff are, and therefore our ability to take care of our clients. We also need our security person there, a national security person. That's critical. No one questions that that's critical. There should be liaisons still with DSO, with CMSO. There's a lot of good that we can find in these different programs and sharing with them. We have learned things from them. We have contributed things to them. I think it's been a good collaboration, but it should be a collaboration. It should not be part of an organizational chart necessarily that says you're reporting to these different people. At the same time, DOG's role, which has been thrust into the executive function way too much, needs to go back to being advisory group. We have a day job, and we're really not designed to do more than an advisory group. Now, I'd like to talk then about three other things, and that is NITOD, our national, this is the heart, the heart, lungs, blood of our IT. We have tried to build it. It is grossly understaffed. We don't have too deep on almost any function. If someone goes out sick and the thing goes down that that person is assigned to, there may not be someone there to fix it. All good professional IT organizations will have too deep at least on the critical functions they're supposed to do. We don't have anybody writing policy and program. We've been trying to get them hired. I think they're about to get somebody on board, but we don't have written policy. We don't have procedures written. This is an appalling lack, and we have not had the staff to do it. They have been scrambling to keep us afloat. We do not have people to look at the architecture of how you build a big IT program. And our IT program is growing and needs to grow. All of these, we did surveys. A year ago, we did surveys. Extensive surveys. We met with experts. We did all kinds of things, and we put in for a personnel request for NITOD. And for the life of me, I can't remember if it was 6 or 8 that we thought we needed. After putting that in and documenting everything in what my budget analyst said was one of the most beautiful staff requests they'd ever seen, they came back and said, we think we may be able to get you 1. I said, well, I'll take 1. We need a lot more. Then we didn't get the 1. This fall, we put it all together again. We asked for 4. So far, we're finally approved for 2, when we really need more. If the defenders ran their own IT program and were able to say, we understand we need desperately a modern practice of law, and to do that, we have to have our IT. We would make sure we could have the personnel we need, if we could fund it. And those 2, by the way, haven't been approved yet either. We still have to go to the FJC or the Budget Committee. We may not get those either. The other thing is this. CJA, even if we get the strong, robust, independent Defender IT program, CJA has been getting almost all of its resources through this gentleman and his team of 4 people. And that is woefully inadequate for what our CJA program needs. It is less, if we are the red-haired stepchild, they're the goldfish in the bowl. They are just not accorded the same things, and perhaps it's because they don't have the presence in the AO we have. But our CJA really need those resources, really need the training, really need to be able to use them, and this is all we have. There's been a proposal by some of my colleagues that it would be very good to have like a specialized tier of CJA, like our Learned Council for Capital, and some places have Learned Council for white collar or financial and some of the other things. But a tier that could be trained, and that if we got the resources, his office should be beefed up substantially to be able to have training and provide national software and get a national program going for CJA instead of what you have right now, which is if I have a problem case, I go to them. But if we actually proactively had a program for them, it would be wonderful to be able to have our CJA being able to do what our defender offices can do. And all of that is so far below. You know the $1 million budget he talked about just for the training facility for DOJ? That's our entire budget for all of our federal defender defense. Finally, true confessions. I started when all of this started, I was a stay in the AO person. We need the protection of the AO. I don't want to be independent. I haven't thought about it that much since. The one thing I have come to the conclusion of is this: Defender Services cannot give us the leadership we need to put this together. They are stuck with a liaison position which does not have the strength. They are trying to do things, but in trying to do things, they are not able to get there fast enough. We have not been able to get the people we need for NITOD, and we know what we need. I have come to the conclusion that we need to have Defender IT have independence. And if we need to do that, then I back into it. I think we need Defender independence. Thank you.
Mr. Broder.
Thank you. I'm going to pivot a little bit broader to some of the points that Ms. Elm concentrated on and talk about e-discovery and the construct of e-discovery broadly, not just the IT infrastructure, which is very critical, but we have IT infrastructure for the Defender system, and then broadly some of the things that Mr. Aoki and Mr. Mitchell and I will probably focus on is technology. And at this point, technology impacts every attorney defending an indigent client against a federal criminal prosecution. A generation ago, when the Prado Committee convened in the early 1990s, technology was even listed as one of the 14 issues to be examined. We know the world has changed. Consider as just one example. As Chief Justice Roberts noted in Riley versus California, modern cell phones are, quote, now such a pervasive and insistent part of daily life that the proverbial visitor from Mars might conclude that they were an important feature of human anatomy. When I think of technology and e-discovery, I'm reminded of Charles Dickens and the famous quote of, it's the best of times, it's the worst of times. On one hand, what attorneys can now do on their own is remarkable. From reading and sending emails on the road, to conducting legal research using Westlaw or LexisNexis, to preparing briefs and syncing files between home, work, and mobile devices, sole practitioners now can do what big firms could do 15 years ago. E-discovery provides more and better evidence than paper. For example, communications between people now leave a digital trail through emails, text, and message logs, allowing attorneys to show relationships and document knowledge of events that would have been nearly impossible in the pre-digital world. And yet, e-discovery also creates significant challenges for parties, as I know you all know. That's due to the high volume of information, the many sources and formats of which e-discovery is generated and stored, the hidden information it may contain, metadata, embedded data, the differing e-discovery production formats, and of course, the software and hardware limitations. The challenges are especially daunting for CJA Panel Counsel. The Defender Program has a remarkable collection of offices and individuals addressing e-discovery in the respective districts. There are numerous computer systems administrators, investigators, paralegals, and I have to say often the unsung heroes dealing with the challenges of e-discovery for offices. AFDs and defenders are thoughtfully addressing these issues. Donna is one person who's been doing that, and she has a number of examples from her own office which can demonstrate if you have effective strategies for dealing with large volumes of e-discovery, it can be an advantage. Doug Mitchell and Russ Aoki have both gone to trial in complex e-discovery cases, and they've learned valuable lessons that they can share with us. That said, to keep parity with the Department of Justice, the Defender program will need more resources to keep up with the demand and growth of electronic discovery. Speaking of the Department of Justice, one of the more positive developments in the last few years has been the willingness of DOJ to reconstitute and maintain an ongoing working group, JETWAG, another acronym, I apologize, but to address the challenges involved with e-discovery. As I mentioned in my submission, the working group continues to operate, and it's looking at things such as suggested practices for providing incarcerated clients access to e-discovery. It's a challenging project since there's clients in more than 1,800 facilities, and many of those facilities don't allow any type of e-discovery. We're hoping that a set of suggested practices will lead to greater consistency in policies and practices and make it easier for clients to have that access. But I would caution it's not going to be a panacea. But hopefully with the proper framework to allow more clients access to e-discovery, it'll help contain cost and improve the quality representation of clients. There's 6 broad points I'd like to make. As Bob Rance said this morning, there is no one-size-fits-all solution. Each district has different needs, challenges, and resources. Secondly, buying one tool or handing the information over to an IT expert is not the solution. People need multiple tools, have a multifaceted approach to the discovery management plan, and council must understand and ultimately be responsible for that overall plan. The speed at which technology changes requires continuous assessment of the technological case needs and flexibility. There are fast developing issues involving cybersecurity. In fact, many of you probably had challenges coming over here because of the large cybersecurity conference going on. Encryption, mobile and cloud technology. It's the kind of thing that people like me who are sort of geeky are glad that now we're talking about some of these issues, but they're having a huge impact, as we all know, on you all and on people who represent clients. Fourth, we talked a little bit about training early this morning. To train people, we do need hands-on programs where people use the technology in similar ways they do their cases, or when possible in their own cases. Sitting in a presentation or two on technology will not do the trick. With the guidance given by Lori Green, Chief of the Training Division, Bob Burke before her, and other attorney advisors, we've worked hard to have hands-on training for the panel and defenders when possible. It's had a positive impact, and it's critical that we continue to do that if we're going to get up to speed. Fifth, although tempting, hitting the print button will not solve the discovery management problems. Critical information will not appear on paper. We also have to be careful about converting native files, meaning the original formats, our emails, our Word documents, our PowerPoints, into basically e-paper, because we need to have the format that's most usable, complete, and efficient. It's what we do in our daily lives, and it's the kind of things that can help us deal with the challenge with e-discovery. In conclusion, I would just like to say that to solve these problems with e-discovery, we're going to need a combination of knowledgeable counsel, experienced litigation support staff, software and discovery management tools. When possible, discovery provided in usable and searchable e-discovery formats, and a table of contents or index to provide context to the case and the discovery contents. Assisting counsel in becoming more knowledgeable about e-discovery, utilizing experienced litigation support staff, and maintaining software and discovery management tools will go a long way towards harnessing e-discovery advantages while containing its overall cost for the Defender program. Thank you.
Thank you. Mr. Aoki.
Thank you. As you know, I'm one of three coordinating discovery attorneys on contract with Defender Services. So we handle multiple defendant cases involving large volumes of discovery. If I was going to summarize what I do in 3 items, it is we help contain costs, we help maintain quality representation, and we train lawyers on the use of technology. And it could be something like avoiding duplicate efforts. We handle drug cases that might have 20 or 30, 50,000 wiretaps. They might have 20, 30, 40 lawyers involved. So thinking about how long it is going to take to go through those 20,000, 30, 50,000 wiretaps linearly, one item by item, 100 hours, 200 hours, and then multiply it by the number of lawyers who are going to be doing that. And that's where we step in to try to build the tools that will allow lawyers to go through them more rapidly, isolate the calls that they need. And we all know that we can't just look at something one time and be ready for trial. That means going back and looking at it several times, and the tool allows them to do that more efficiently. For big cases like fraud cases, we're maybe dealing with millions of pages of documents, millions of emails with attachments. We put them on a database, something that's web-based. One of the things we look at, three things we look at are, is it easy to use? Knowing that the user is going to be a sole practitioner or somebody with limited technology experience, is it secure? That we always only use databases that have third-party security audits. And also, is it going to be something that we can continue to work with and have some good technology support? Because much like your own Windows operating system, it requires security updates all the time. Web-based databases need that too. They're always constantly being innovative. They're trying to make themselves hack-proof. They're trying to make it easier to operate now too. But one of the things that we use for it is avoiding lawyers from doing that linear page-by-page or item-by-item review of millions of pages of documents. You cannot do it. You cannot do it within a few years. You're talking about 10 years to get through some cases. So trying to get them engaged with using technology, and we're talking about lawyers who've been practicing 20 or 30 years who are three-ring notebook lawyers, and they want it in paper. So getting them to be engaged with it means that's training on our part. So that means making the database palatable for them. We'll do something as simple as the initial organization of the work, saying this is how you can create folders of every defendant, of every witness. We go through the indictment. There's certain businesses that are referenced all the time. And here how you can create a folder for that. And when you do the searches, you can put those documents, tag them accordingly. And most of all, it's the training. And we found that database companies, they really are built for civil litigation. And they're built for civil litigation that have technology departments. So we have to take over the training. We work with either the database company to really understand criminal defense, criminal cases, that we don't do redactions, we don't produce documents, that we're dealing with multimedia formats. And for our most complex cases, that we do the training ourselves, because we understand what the lawyers are looking for, how they're going to get to it, and what really they care about the most. In terms of our workflow, we look at it as two stages. One is we get the discovery, take a look at it, and get it out to all the defense lawyers as soon as possible. Give them some kind of tool that they can review the documents immediately, assess the case immediately, so they can address detention hearings, pretrial motions, so they can make a determination where they identify which cases are really going to go to trial. And that means we take a look at it. They're corrupt files. Any big production case has corrupt files. Documents may not be searchable. We see typically, very often, cases where large productions of PDFs are produced to us. They're OCR'd, meaning they're searchable, except for the Bates number. And when you get down to the last couple of weeks, everything's going to be referred to by Bates number. So our office will re-OCR everything, which would normally cost anything from 2 cents to 5 cents a page. And when you're dealing with tens of thousands of documents, of pages of documents, it really adds up quickly. We do it ourselves in-house. If we sent it out by the time we got funding requests, by the time the vendor got around to it, we're losing valuable time for the lawyers to have this assessment. Well, it used to take us months to be able to create a sortable spreadsheet so that you can sort through and find the wiretaps for particular target numbers that are being called, number of calls that are to a particular number. Used to take us 2 or 3 months. We worked with several technology companies, tell them this is what we need. We think you can do this in an automated fashion. To take those 5,000 line sheets, they're all in one PDF, and use an automated process to break them all up and match them to the audio. So now we can get those out in a week to 2 weeks. It really is a critical tool for the assessment of drug cases. I think that when we first started working on this, I first started in the Western District of Washington, and then since 2011 working on nationally, people didn't know what to do with the CDA or what the CDA involved, and there was some confusion as to whether we had some control of the way they handled their cases, which we don't. We're the support team for them, that we come in and help them right away in terms of maybe creating strategies to handle their cases. We had one case early on from we filed a petition for the appointment of a CDA ex parte, but there was one jurisdiction where the government got wind of it and opposed it. Opposed it because based on taxpayer, money shouldn't be dedicated to spend money on Russ Aoki. And so they're not really understanding what a coordinating discovery attorney does, but things are so different now. Now I'd say these lawyers are reaching out to us every week for help. Courts are telling defense lawyers, go find a CDA. This is a case that needs a CDA. And I'd say the last 8 months, we probably got 4 cases that were initiated by the U.S. Attorney's Office who went to the defense lawyers and say, this is going to be a big case, you're going to need to get a CDA involved. And so I think it really says a lot about the acceptance of what a coordinating discovery attorney does. I think the comfort also is because I'm a lawyer. I'm a CJA panel lawyer. I've been practicing for a number of years. I've been in court many times. I understand what the sole practitioners go through, small firms go through. I also understand the importance of maintaining the integrity of the evidence. For example, when documents get scanned, I want to make sure there's an index that if there's ever an issue of the genuineness of the document, I can track it down to that actual box and pull the original document out. For databases, when you're looking at a document on a database, we make sure that displayed on it is what's called a relative file path, which means you're looking at this document, you can tell it came from this folder, from disk number 13, from production number 20. So you can go back and track it again as to where did this document come from. And I think also because I'm a lawyer, I understand the rules of professional conduct. RPC 1.6, maintaining confidentiality of materials being used in the representation of your client. I think before the DOJ started encrypting, we have been encrypting our productions for several years prior to, and training lawyers to understand why it's important. Yeah, it's government discovery. They've looked at it, but it's something about their clients. They don't want them floating around. So we want to make sure it gets transmitted in a secure way. And also 5.3 is a lawyer's responsibility to make sure that vendors are keeping everything confidential, are doing the proper work. And we make sure that when we work with vendors, they understand our work. And we will educate them. And we work with vendors for several years in making sure that they understand what our needs are, who the users are going to be, and that everything is going to be maintained in a confidential way, in a secure way. Because occasionally, and we certainly had this happen on one occasion, where the government wanted to know if the lawyers are accessing the database and when they're accessing it and who's accessing it. The database company has to know you cannot give that information. Absent an order, you're not going to give that out. And how many database companies would have folded as soon as somebody flashed the FBI badge in front of them? And so understanding the importance of our work for the vendor, I think that's another big attribute. This has been an interesting opportunity for us and a rewarding opportunity for us to be involved. I think in terms of being a lawyer, to me it's always about giving something back to the community, promoting our profession. And being a coordinating discovery attorney, we get to work with who makes up the most lawyers in our country, sole practitioners and small firm practitioners, and that we can impact the community by helping improve the quality of representation. So we look forward to helping in the future.
Thank you. Mr. Mitchell.
Thank you. I realize that the committee is reviewing issues relating to the CJA program that extend far beyond the topics that we'll be addressing today. But today's topic is perhaps as timely an opportunity to review the CJA program in meaningful ways as any of the others the committee will be considering. And I think it's timely because, as I'm sure everybody here appreciates, over the last several years, there has been a change in the things that appointed counsel need to do in criminal cases. And that change is largely a function of changes that have been taking place in society at large. I think studies that have been done by the University of California at Berkeley and others have concluded that today 95% or more of all of the information that is created in the world is created digitally first. And it's all maintained in some form or another during its lifetime digitally. And what that means for appointed counsel who represent defendants in cases in front of courts is that the evidence of what people did and what people said is increasingly digital. And the evidence that then has to be brought to court in order to present a client's case is increasingly found through an analysis and review and synthesis of digital things. And as a result, we find ourselves in a period of time where we're transitioning from a paper-based world into a very digital and intangible world. And that transition, like almost every transition we encounter in various aspects of society, entails certain inefficiencies. It creates certain issues that didn't exist before the transition period began. And like every other aspect of society, the attorneys who go through that same transition have to adapt, and they have to work through the inefficiencies in order to make what is unfamiliar become familiar again. And the inefficiencies arise in areas such as just a lack of familiarity with the information and discovery and evidence that the attorney needs to work with in order to prepare his client's case, in order to understand what evidence exists of what people did and what people said and what they knew and what they intended, so that they can then advise their clients, and then they can also take that evidence, cull it down to the very most important and very most material pieces of evidence that they then can use to present that client's case to a jury at trial. But when you have attorneys who are unfamiliar with the form of the evidence or the information, because it comes to them on a hard drive, and it comes to them in a form that's a forensic image that may be encrypted, and all of a sudden, for the first time in that attorney's career, he has to figure out how to access that information. He has to figure out what to do with it so he can review it, and then he can then understand what he needs to know in order to advise his client and prepare his client's case to the best of his ability. The inefficiencies exist because very often when there are these technological changes in society, it takes a few years for the support industries, in this case the litigation support industries, to catch up with those changes. And so very often the tools that are available for a lawyer to analyze this new kind of information are inefficient, and it takes a little longer to use them. Inefficiencies also pop up because not only are their tools lagging behind, but even more certainly, the lawyer's familiarity with those tools is also lagging behind. And it takes a little time. It takes a little time for the lawyers to learn how to use those tools effectively and efficiently. It takes a little time for them to then go through larger volumes of data, think in larger patterns so that they can synthesize the specific pieces of evidence that they can use to support their client's case. The inefficiencies also pop up in terms of time itself, because it does take longer when you're unfamiliar with both the material you're working with and also the tools you need to use to work with those materials. Inefficiencies pop up also in terms of the time it takes for lawyers to develop the skills they need to deal with the new information and to use the new tools. And these periods of transition almost always entail not just inefficiencies in terms of the familiarity with the materials and the tools, and not just inefficiencies that arise in terms of time, and not just inefficiencies that arise in terms of skill sets, but also inefficiencies in the form of additional costs, because it takes longer to do some things than it used to take. it sometimes costs more because the resources that are necessary to access the information and make it usable cost money or didn't exist before, and therefore it costs more to use those tools. And it seems to me that one of the great challenges that confronts this committee, and as it reviews the CJA program as it is now, is developing a set of recommendations, a set of policies and practices that can be implemented as first principles that will help the CJA program develop a set of attorneys who can use more efficiently the information that's now being disclosed by the government in criminal prosecutions that involve forms of electronic discovery, who can use the tools that are necessary to access that new kind of information that's being disclosed, who develop the skill sets for reviewing large volumes of data efficiently and effectively so that they can sift through the haystack to find the few needles of material information they can then present at trial. Because I'm sure as everyone can appreciate, there may be millions of pages of paper in discovery, but at trial, everything comes down to just a very few. And it comes down to that few set of documents, those few witnesses, that an attorney can then craft into a persuasive narrative, a persuasive story that can be admitted into evidence, either in the form of witness testimony or document evidence or other types of evidence that will be more persuasive than the story that the prosecution can tell, using the same haystack. And it's the process, and I think it's the challenge of the CJA program, and the committee in particular now, to find a way to develop that set of talent or skill set among the attorneys who are appointed to represent criminal defendants. The Department of Justice has taken on that burden, and they have invested large sums of money to ensure that their prosecutors, both in the Department of Justice and those in the individual U.S. attorneys' offices and districts throughout the country, are capable of dealing with the types of evidence that they are seizing as they go and investigate criminal conduct, and the types of evidence they need to review to determine and identify the specific pieces of evidence they'll present at trial, and then the way in which they'll present that evidence at trial. They have invested a great deal of money, a great deal of time, and a great deal of effort to raise the level of their attorneys to the point where they can do that. And the challenge for the CJA program will be equally great. It will be in some ways more difficult because unlike the Department of Justice, which is a hierarchical, monolithic structure in some respects, and maybe not in all respects, but in some respects, the CJA program is a distributed architecture. There is no centralized system that controls or dictates the behavior or policies applicable to each of the solo practitioners or the small law firms that are appointed to represent attorneys. And so it becomes more difficult. It becomes more difficult to build the skill sets because CJA attorneys very often don't have the resources to do it themselves. It becomes more difficult for CJA attorneys to acquire the resources on their own because they don't have the financial wherewithal to do it. It becomes more difficult for any number of reasons when you're all by yourself and you have no support other than a secretary who helps you from time to time organize and type and prepare. And so the task is a daunting one, but I think it's a task that's capable of being accomplished. And I think it is something that is also a very meritorious effort. It is a terrible thing to sit in a courtroom at a calendar call and to watch other attorneys stand up and announce to the judge that they are prepared for trial, which will begin in a week and a half to 2 weeks, knowing that the attorney who stood up and announced that he was prepared for trial had not yet even attempted to look at 2 hard drives that were full of electronic evidence that the government was prepared to introduce against that attorney's client. It's a terrible thing to have that happen, not just to the defendant, but to the justice system itself, which needs to have the appearance of impartiality, the appearance of a level playing field, and the appearance of fairness and justice for everyone that comes before it. It's also difficult for the courts, which, after that trial is over, are faced with 2255 motions and petitions, where that defendant, who then on appeal or after appeal has been exhausted, comes back to the court and says, "Oh, but Judge, my attorney never even looked at the information that was on those 2 hard drives, and so I didn't have the effective assistance of counsel." And so I'm grateful for the opportunity to appear before you today, and I'm grateful for the opportunity and for the committee taking the time it is taking to consider these issues, because it is, I think, an important issue. It's an important time to have this review, at least with respect to this particular subject matter, and I'm grateful for your time. Thank you very much.
All right, we'll start with Mr. Khan.
Let me begin with Donna. What I'd like to do is sort of move from your conclusion.
You need the microphone. That's
I'd like to move from your conclusions backward and understand why your concerns about Defender IT lead to a conclusion that the only solution is Defender independence. So, as I understand it right now, the real problem we have is a disconnect between the operational side of Defender IT technology, the people who sort of manage the network, the programs that Defenders use that contain confidential information, and the people who administer it, the people who control procurement and compliance and, interrelationships with third parties. And those are split now, and one group doesn't have full access to the other because they would be breaching ethical rules if they did. Is that right?
Yes.
Okay. So the first question would be, why can't we just put them back together? For many years we had DSO administrative control over IT, and NITOD, the operational side, was effectively under direct Defender control in the Western District of Texas. Why isn't that an adequate solution?
That did work for a number of years. And I've thought of that quite a bit, Mr. Khan. It did work for a number of years because we did have strong leadership in DSO, in Defender Services, that was providing the leadership, and Defender Services was providing the support. It worked pretty well, but we keep getting further and further behind. And when we stop and look now at how far we are behind DOJ, when we're supposed to have parity, it didn't move us forward as fast as it should have. Secondly, when I look at where we are right now with our liaison position and what Defender Services can do, they can't get us the personnel we need. And it's not through a fault of Kay Clark. It's not through a fault of CMSO. I think it's structural. They are in a position where they just can't get the sorts of things they needed when Ted Litz had a higher position. And with this demotion of Defender Services, for whatever reason, we cannot get a strong person in to run Defender IT. I mean, I met with Kay Clark saying we need this, and apparently we're kind of stuck with a lower level person. We may need some extra people in IT. Just trying to get extra bodies has not worked. And it certainly has not worked despite a whole lot of effort in NITOD.
You know, I'm hearing what you're saying, and maybe I misunderstood your first position, which is because it sounds like what you're saying is that DSO independence, DSO ability to control its IT infrastructure and our IT relationship with them would fix this need. Or are you talking about big I Defender independence, removing the program from the...
No. I'll tell you what I'm talking about. I'm talking about Defender IT independence. And to get that type of independence where we can manage it, in the structure of the AO right now, DSO is not able to do it for us.
Okay. So let me go back one step, though, and ask you, right now, so one problem is that we have inability to get on board people who we need on board. Another problem is that we're having difficulty moving forward with technological advancements that we need to make, or I shouldn't say advancements, just sort of basic maintenance and functionality of the basic programs we use. But the obvious question to be asked is, why can't we fix those problems with small tweaks? Why can't our memorandums of understanding and a greater commitment to resources adequately deal with those problems?
Well, we have tried earnestly to get a greater commitment to resources. It is appalling that we don't have even staff to write procedures, that we have an administrative... We're part of the administrative office of the U.S. courts, and we don't have somebody who can even write policy and procedure. We're just barely trying to get that after well over a year of having identified it as being absolutely critical. And the one deep problem, and we just can't seem to get there within this. I mean, yes, I don't have a problem with us staying within DSO, within the AO, if we can get those things. The problem is, we can't.
Let me ask a question about the pace of technological advancement and where we are relative to civil firms or DOJ. And, I think you've given some description of that, and that we're well behind and probably falling further behind, and I think everybody understands that. But we were behind before the reorganization. I think that's fair to say. How do we begin to address that problem? So let's say we have Defender IT independence. That alone doesn't catch us up. What do we need to do to catch up?
Well, one of the good things we got from the work measurement study was discussion by Harvey Jones, who's with HR and led that statistical study, about when he found out that we had a ratio of, I believe, 35 staff to one IT person within the Defender offices, and that some of the others, and I'd be happy to provide the committee with the actual numbers. I'm trying to remember this from a year ago, but I think bankruptcy has 9 to 1. Probation, I think, has about 15 or 18 to 1. And we have 35 to 1. And so if you're trying to move...
Do we have any information on what DOJ's ratios are like?
No, we don't at this point. The other thing I would just distinguish is, and you're right to bring in DOJ, is that there's the IT infrastructure for litigation versus just IT infrastructure. And for now, we're really just talking about IT infrastructure.
Yeah, we're just talking about keeping the computers going. So one of the things that came out of the work measurement study was the concept that Defender offices across the country needed to have a much lower ratio to try and even get us close to where the courts, probation, some of our fellow agencies are, let alone DOJ. And DOJ, I dare say, just from the information that Mr. Broderick gave you, is well ahead. We have suggested that maybe the ratio we need to aim for is 20-1. It may be lower, it may be higher, but that might be a much better ratio. If so, we'd have to almost double our IT staff nationally. And that's just within the Defender offices. As we're trying, and I've been talking with a lot of defenders about beefing it up, start to hire more IT, start to get your IT program going, hire paralegals who can do more of the litigation support work, hire people who can do forensics, so you're doing it in office and cheaper. And then we realize that it runs on the stomach of NITOD, that you have to have your national IT there too. And even though defenders are given a large number of FTE, of full-time equivalent employees, that they can choose who they're going to hire or what type of person. They may say, all right, as I did, I'm hiring me 2 more IT people for my office right now. NITOD is a national program, and it's because of its position as a national program, we have to go through so many more hoops to try and get bodies in for it. And it turned out to be very difficult barriers, like I said. We have recently been approved for 2 after working really hard for and having a go at it twice, and it still hasn't gotten final approval.
Let me just clarify something you just said. You said it's because they're a national program, it's particularly difficult to add resources that we need. And is that a result of the transfer of staffing jurisdiction from the Defender Services Committee to the Judicial Resources Committee? Is that what's created that difficulty?
I think, Mr. Khan, you know better than I, but that's my understanding. And I don't know if it's a budget issue. I'm not as involved with that, but I do know that it has been extremely difficult when we have desperate need.
So I'd like to turn, do I have time for a couple more questions? I'd like to turn to a quite slightly different area, and that's, and I think Sean and Russ, you're the ones who probably can answer this question, and maybe you also, Mr. Mitchell. You know, first of all, I appreciate tremendously the work you do. I can't even imagine the sort of scale of the task, and so that's what I want to ask you about, is what's the scale of the task? Has there been any comprehensive assessment of what we need to do to put defenders aside for the moment, but to get the panel lawyers the level of technology that they need, not to be on a level playing field, but just to be able to offer competent representation in this new world in which, you know, a simple drug case involves, you know, gigabytes and gigabytes of data. So whoever wants to answer, please.
I mean, I'll say that the short answer would be no, we don't. I mean, one of the points I made is technology is moving so fast that it's hard to figure out what should be the metric to determine what are the needs and where we need to go and what are the expectations. What we have been doing, the National Litigation Support Team, we've been doing a fair amount of trainings locally to work with different offices and trying to actually have more hands-on, I should say, offices, but also CJA panel, try to assess where they are at. But we have not come up with a comprehensive plan to just say, this is the baseline where we need to go. Russ, I think your district in Western Washington did have come up, and this is actually now a few years ago, came up with an idea of sort of a baseline assessment of technological skills or equipment that the panel attorneys maybe want to have.
That's correct. Understanding that the complexity of cases now, our jurisdiction put together a list of the kinds of equipment that a lawyer needs to have to be on the CJA panel. To us, it's a pretty basic way you operate businesses, but for a lot of the lawyers, they had to go out and purchase some equipment, some products to be able to do things using like Acrobat and be able to do OCR and search. But
could you tell us real quickly what were the sort of basic tools that your assessment led you to say that every CJA lawyer ought to have?
I'm sorry?
Could you give me a list of those basic tools that CJA lawyers ought to have?
For example, the ability to scan, the ability to use something that can convert a document into a PDF or some search and be searchable, which would be like Acrobat Professional. Sorry, I don't have the list in front of me, but it's
It was fairly basic, as I recall. I mean, it was sort of word processing, email programming, and this was a number of years ago. Then this came up.
The idea was to start with something pretty basic that we assume everybody's going to have, but understanding that some people didn't, and then start building from that.
So a couple of questions related. One, can you later, after this testimony, provide us with that list? And the other question was, can you give me an idea of what percentage of the panel in the Western District already met that standard and what didn't when you did your assessment?
We did not do a survey. We were aware of some panel members that we questioned whether they had the capabilities. Based on statements that they made to the court. We were dealing with District Court Judge Marsha Peckman and Magistrate Judge Mary Alice Tyler, who had explained their concerns of what they had been hearing. But I'd say it was a very small percentage. But since we didn't conduct a survey, those few people had raised the concern of, well, maybe what if there's a dozen people out there like that? So we wanted to make sure that it was clear.
Okay. One last question, and so it seems to me that one of the most critical problems we've got is we can't get where we need to go if we don't know what we need to do, and so we clearly don't have a national assessment of needs, and therefore we don't have a strategic plan. Is there any incipient movement towards accomplishing those things so that we can begin to then determine what we've got to do in this area?
Well, to clarify, there has been, and as Judge Cardone knows from the work with the Defender Services Committee, we've had a number of strategies involved to serve as this interim step, and including those things has been getting a number of software products at a lower discounted rate, working towards having more the possibility of using web-hosted databases in certain select cases, and taking advantage of having coordinating discovery attorneys. And it's part of the reason why my submission noted some of the things to look forward to. But I think this is a good time to revisit where we are now and see if there's a way to sort of figure out where the baseline, what would be good things to have as a baseline, and figure out ways to make it easier for the panel who already have, as we noted, solo practitioners who have a lot of demands put on them, but see if there's some ways to assist in that process.
So I said one more thing, but I'm going to make a request of you, which is that since I love to give other people work, would it be possible to have all of you consider what you would suggest in an ideal world for a plan to come up with this plan? What would you want done for us to develop a plan which we could then pursue? And maybe submit that to us sometime down the road in the near future. Thanks.
And I will just say that is one of the things I did list, but we can put in my submission was some of the things we talked about was having additional staff for CJA panel attorneys, looking for potentially more CDA contracts, and thinking about having specialized, and this is something that Mr. Mitchell talked about, especially for the large mega case, having attorneys who are more comfortable with dealing with technology and have more resources to take the lead on those cases.
Yeah, I'm done.
Okay. Okay, well, no, you can also, but to Mr. Broderick and also to Mr. Aoki, and that would be, first of all, thank you for your testimony. As a committee member, I'm being educated in this area. And one of my questions, kind of follow up from Ruben, is the scope. And that is, I did notice, Mr. Broderick, in your written submission, your possible future steps, and two of them that you've just mentioned, one of them being additional CDA contracts to provide assistance in specific cases. I would want to know how many. You don't have to answer it today, right, but we would want to know as a committee, what are you looking at as part of the plan, how many? But I would like to know how staffed or understaffed you are now, or as far as CDAs, how broadly they are used in geographical
Certainly.
areas? Because I know in certain areas of the country, you're used extensively, in other areas, you're not used at all, and you're certainly being underutilized. And so I guess I would like you to educate us a little
Certainly.
bit as far as, one, the coordination between the two offices, between National Litigation Support Administration and the CDAs, the coordination there. And then number two, how broadly is the utilization?
So I will tell you at this point, I think we have 3 people who are on contract on the national level for coordinating discovery attorneys. Russ Aoki in Seattle, Shazin Asim in Kansas City, Missouri, and Emma Greenwood in New York. And right now, our initial plan was budgeting 10 cases, active cases per CDA. At this point, between the 3 of them, I think it's up to 60 cases. And actually, they have cases in, I believe, 11 of the circuits. I think there's only one circuit where we don't have an active case. So it's certainly being utilized a fair amount. I will also say that one of the things with technology and one of the things that works with the CDAs is as people become more comfortable, the idea is they get more used to sort of, for example, one of the things has been sortable spreadsheets we talked about. And now we are finding more people who are able to do that on a local level, and you see some people doing that where it doesn't necessarily require a coordinating discovery attorney, because the hope is as we build along and as we continue to do more training, people feel more comfortable, they feel more comfortable working digitally. And so it becomes less of a foreign thing. So hopefully that, we'll adjust the demand, but also that people are more comfortable with cases they couldn't have handled 4 years ago. And if you want to build on that, Russ.
Yeah, we're very busy. We're very, very busy.
And I guess I want to scope of that. I mean, could you use another 2 or 3 or 4? So, I mean, you can tell us.
Yeah, absolutely. Yeah, I think part of the measure or the threshold question for us is the kinds of cases that we get into. A few years ago, it was less data, fewer multiple defendants, and now the cases have to be very big, almost an unusual case for that jurisdiction. Some jurisdictions just have a lot of big fraud cases or big drug cases, and may have several cases there. But
so, in other words, there's a missing piece there. In other words, you're in what I'd call the mega cases now. But I mean, there are a number of cases that could utilize your services that just aren't being utilized.
And there's some of those cases where the 4 of us, the National Litigation Support Team, will do some direct assistance on those kinds of cases, basic kind of things, focusing on tools, focusing on, for example, here is a sortable spreadsheet. So it's something that is objective, and so as not to get into any kind of significant analysis. And so we pick off some of those that we can, sort of the low-hanging fruit, and then work on our training to focus on also the basic cases so that people can apply those skills to the more complex cases. Because it's easier to work on a case that you know well and you know how to do, transfer that into a digital context, and then you become more comfortable with the tools and what you can do.
I kind of
All right, Judge Goldberg, that's okay.
Ms. Elm, I want to ask you a couple questions about this transfer of the IT from Defender Services to the CMSO. I'm not unsympathetic about your concerns. It's probably a bad analogy, but let's say Congress somehow said to the Department of Justice, your IT is going to be managed now in conjunction with Department of Agriculture or something like that. There would be a revolt. So I totally get your concerns, but I want to ask you a couple quick questions and then try to get a deeper understanding. You say in your submissions, you're concerned that some government entity, you don't specify which one, but maybe you're most worried about DOJ lawyers, could subpoena your electric case files. Has that happened, or have you gotten wind that that's about to happen or may happen?
I predicted that would be a question. Let me answer it this way. Right now, they can't, because they are kept within the umbrella of confidentiality. If our files go on out to a third party, now, do I know that I'm going to have a defense attorney running in screaming, "Don't let them do this"? And most sentient and thoughtful judges would say, yeah, really, no, don't do that. Don't give them that file. That is their case file. But if you look at what's happened in things like just attorney-client communications, when an attorney and client communicate and it is something that is overheard by a third person, it's waived. You know this basic law, and that sometimes it's applied even in areas that are a little out there.
Has a party adverse to the defender community ever made that argument that you're aware of presently? And I realize the changeover just happened.
But they couldn't.
They could,
presently.
of course, they could.
They couldn't presently on our
Oh, they couldn't.
files.
Okay.
But all we need to do is have somebody realize that we have waived confidentiality. And I predict it would go there. I would also predict that most judges would step in and say no, but could it? Yes.
And again, I'm not unsympathetic to your concerns. Has there been, and I realize that didn't happen too long ago, 2013 this happened? Is that right?
I'm sorry?
When did the transfer happen? 2013?
2013.
Okay. From that point in time to...
Actually, not the transfer of IT at the beginning of 14.
Okay.
The beginning of 14.
Has there been any compromise of attorney-client communication or work product communication that you're aware of during that time period? Zero. Okay.
We have been really watching it very carefully.
So just more generally then, so I can understand it a little better, what is the information that is being now jointly overseen? Is it, I have no idea, I have a Department of Justice background, so I have no public defender I tried a case against was ever showing me their data files, okay? So what is in there that you're concerned about? Are there actual client communications? Are there strategies between Ruben and Catherine about how to try cases? Is there data information? All of the above? Tell me what's in the databases that you're concerned about, without divulging the specifics, because that would
Yes, of
defeat
course.
defeat the whole purpose.
Of course. There's basically 4 things we're concerned about. The one is your traditional attorney-client privileged information. And we have that in a number of places. There are client files, of course, and a lot of us keep client files just within our district. They're not on the national. But our national case management system, Defender Data System, which Mr. Kalar will probably talk about tomorrow, our national case management system has a place for notes, for all kinds of information about the case, and there's a number of us who use it for our case log. Okay. That means that we have client communications, we have all kinds of information. We have our emails, and we often are involved in email discussions with clients or with other people, with witnesses, with our experts. That's in our national system. And so we then start branching out to work product. When we're talking to each other, that's in our national system, and all that's in NITOD. Then we go to, there are places where we may keep records and documents which have some of the private information, financial information, things like that.
A lot of important material, including attorney-client communications.
Correct.
So if we...
There's also, though, and forgive me,
Go ahead.
but we consider our case data to be at least sensitive because it is the basis. We're very careful about our case data. which is like our numbers and how much time we put in on cases. And all of that, too, is very sensitive, and that usually is not going to be released without discussions with the defender.
Hypothetically,
Sir.
if our proposals, this committee's proposals, were completely 100% accepted by the Judicial Conference and Congress, what would the specific fix be that you would like to see? Be as specific as possible.
We need to be able to hire the people we need for the national, I'm not talking about the offices, I'm talking about the national program. We need to be able to hire people to at least double our NITOD staff. We need to be able, we have just recently greatly increased our bandwidth nationally, so now we need to be able to start using it more. We need to be able to put someone in place. If we stay within DSO and Defender Services has a greater capability to be able to put people into this position, you might, I'm not saying how you go with this, but if Defender Services still exists and we are in it, we need to be able to hire at least 3 people to staff.
More staffing and have the IT back under the sole umbrella of Defender Services.
And to be able to move much more quickly in trying to get things done. So that's a lot of my concern, is that we have to go through so many administrative hoops that we can't get anything done.
One question for the panel, whoever wants to chime in. I think we're getting a lot of information, and maybe one theme that is emerging is underutilization of CJA lawyers, of experts, all the above, investigators, experts for sentencing, psychological experts, and experts of your ilk, data experts, coordinating discovery experts. What advice would you folks give us on how, and maybe this is not our task, but maybe it is, how do we get the word out to the CJA lawyers who are not in the bigger cities that these resources are available? Because I think, Mr. Mitchell, you said, and you were right, the DOJ lawyers, they're being taught this. Well, I remember when I was at DOJ, and I said, well, let's get the particle boards with all our exhibits and put them in front of the jury. And the agent said, no, we're going to do this by computer. We have a database. And so that's how I learned, started to learn how what resources are available. You're right, DOJ is this big, what's the word you use, monolithic? Monolithic structure.
Monolithic hierarchy.
Yeah. They're doing a great job educating the lawyers, but how do we, you posed the question, I'm going to throw it right back at you. It's a problem. How do we alert CJA lawyers that these services are available? How do we do it? How do we get the word out to them? That's the first step. These services are available. We've got to learn this.
I think it's a multifaceted approach. I think the first thing is there must be a top-down recognition that those services and support resources are both available and necessary in the right kind of cases. And that comes from the national CJA people like Sean Broderick and his team that do a phenomenal job of communicating as best one can from a pinnacle sort of position down. And that has to continue. The second thing I think that has to happen is there must be a communication of the necessity and availability of those resources to the district court judiciary. I think there is a need to make the district court judges familiar with and comfortable with the idea that some of these ancillary resources and support services really are normal and necessary and reasonable in the context of today's litigation, so that there is not this discomfort at the judicial level with the kinds of resources that are being requested. both in terms of what the resources are and also in terms of what the cost of those resources are. Because sometimes the cost of the resources can seem exorbitant. But when you factor the cost of a resource against the attorney time that it would take to perform the same tasks without the resource as it would take with the resource, the cost of the resource is nominal.
Not just educating the CJA lawyers, educating the judges.
Right. There's a judicial education.
Yes.
I think, because there's a hesitancy to think, oh, no, I have to spend $400,000 on this online review platform, and they want to do this kind of objective coding, and they want to do subjective coding, and they want to use predictive coding, and they start talking in a language that's unfamiliar to a lot of judges. And when you add on the cost of that, the lack of familiarity coupled with the cost, I think, creates hesitancy. So I think there's a judicial component to it.
One more
to the
quick question,
education.
because I'm sort of hogging the microphone, and then I'll turn it over. Are judges, in your opinion, and I want to hear what Mr. Okai has to say and Mr. Mitchell, and I guess all of you, just yes or no, are judges supporting, based on what you've seen, are not supporting the use of this technology that's, we all agree, has to be used? Let's just go down the road. Yes or no? Are they supporting it or not?
They are supporting it, but a lot of times there's sticker shock when they find out how much it might cost.
What do you think?
Same response.
They are supporting it, and I think part of it is because this is the same judge that has appointed me to be the coordinating discovery attorney, so trusts my opinion that I know what I'm talking about.
And I think I can speak mostly for my district, and I think we're very fortunate to have a group of judges who are aware of these situations and provide us with the resources. But I do know that I receive telephone calls from time to time from CJA attorneys in other districts around the country who ask questions about, how can I help my judge understand the following? And so there is some, I think there's a desire to provide the resources. And I think judges generally have a sincere, intention to help where they believe it's appropriate. The problem is making them familiar with and comfortable with what that means in today's litigation world. And then there's just one last little thing about the levels of things that need to be done. I think there also has to be an effort, a concerted effort on a district court, a district level, not just to have the kinds of training and notice that come from Sean Broderick and his team, and not just the kinds of things that would come from a judiciary that's familiar with and comfortable with these kinds of resources. But also, there needs to be sort of a collegial training and education among the appointed counsel within a district where there is a regular sort of, I don't know if training is the right word, but skill set building over time so that they become comfortable with it in a collegial colleague kind of way as opposed to a top-down way. So I think it takes both. I think it takes top-down. I think we need to have the presiding authorities comfortable that it's reasonable and necessary. And then you need that collegial support structure that comes when peers are talking together about doing things in the best way possible and sharing their experiences and building one another.
Before I pass to Judge Gerard, I just have a question for Mr. Broderick or Mr. Aoki on this topic. I know that counsel throughout the country reach out to you, and one of the things we've talked about is how often it is that judges don't approve budgets or don't approve experts, et cetera. Mr. Broderick, Mr. Aoki, do you have any have either of you sought to help a CJA panel attorney in a case and been told your services were not going to be allowed? And if so, how often has that happened? Are you following what my question is?
Mm-hmm.
In other words...
Yeah, right. With our services, I have not experienced that for ourselves, partly because there isn't, we're a service and there isn't any cost involved with that. So our team hasn't experienced that kind of reaction as far as not being interested in the kind of support that we provide.
So for you, if they contact you and reach out to you, do you then get communications from throughout the country, or is it very regional?
No, it's pretty much across the country at this point.
Okay.
It's all over the country, and it really varies. Sometimes it's someone who's like, I've got 3,000 pages, I don't know what to do, and because for that district and that particular division, they haven't dealt with those issues, which is great, because like, okay, we have some good solutions with that. And then you have the more challenging ones where it's terabytes of data and there's a short turnaround, and that can be a more challenging thing, but we're getting the gambit of requests for assistance, at least conversations, which usually is working backwards with them of going, okay, what is it you're trying to do? Because there's a lot of things that are possible, but if you can work backwards, it gets easier.
I'm sorry, the question was pertaining to our appointment to?
You're right.
So far, we've been very receptive. There was one incident where there was a petition for my appointment and it was denied, and I don't know the basis for that, frankly. But I think total, I'm close to 70 cases that I've been appointed to, and that was the only incident.
And that was only once that you were denied?
Yes.
Okay.
Could I ask a quick follow-up on that, though? Because you're appointed in these cases, and sometimes you'll recommend, third-party vendors to provide services in those cases. Have you had any problems ever with those recommendations of third-party vendors being denied by the presiding judge?
No, I mean,
You've had some pushback in some cases.
yeah, I mean, they ask good questions. The court asks good questions about, because they can be big-ticket items. And when you're dealing with a terabyte of data, you really don't have alternatives and be able to look at it. They're forensically preserved. They have to be unlocked. The metadata has to be preserved, the dates, which is the dates and times. We've had pushback by one court in terms of the expense. The vendor responded back by continuously reducing the cost of it, which, great for that particular court, kind of bad for us because vendors aren't going to do that in the future. And so when we go back to that jurisdiction, they go, why does this cost 3 times more? Well, because the vendor was trying to get their foot in the door, so they kept reducing the price and reducing the price. But that was the only. One thing that I find very helpful, the case budgeting attorneys have been just actually really very wonderful about this, because they understand. They've been most of them been in the trenches. They know what it takes to defend a big case. And so I always try to make sure that they're aware of what I'm doing in terms of what I'm going to be asking for the court.
One thing just to follow up is that, as Ms. Elm pointed out, and you all might not be aware of, is that we referenced the pocket guide that just recently put out by the FJC. And one of the things is we're trying to get more judges to understand, and this was a joint project with representatives from the Department of Justice. And in that, for example, talking about something that I think a lot of judges probably haven't dealt with, which is online databases, and not just a repository like Box or Dropbox, but an online system to do review. And I think in the long run, that is one of the tools that is going to be for the larger cases, can be more useful, because you can assist lots of people. You can move the IT infrastructure out from an office, so it's not as much of an impact for a CJA panel attorney. And Mr. Mitchell, I know you could talk about this because it is sort of a very standard process in the civil world to use database systems like this.
I think it's one of those tools that should be used in almost any case that has any appreciable electronic information at all. And in many cases that are now paper cases, but all the paper has been scanned into some sort of digital format. I know that in our civil cases, where we represent clients who have millions and millions of pages of paper and zettabytes or whatever they're called of data, we don't do cases anymore unless the discovery in those cases are loaded into some form of online review system. It's impractical, it's inefficient, for instance, to take a PST, which is a file that contains an individual's email that had been sent or received using Outlook. And there might be a gigabyte-sized PST that might have 150 or 200,000 email in it. And then to try and review those email by loading that PST into an attorney's Outlook and then going through it one at a time that way is a inefficient and ineffective way of trying to review discovery. And so these online databases become very efficient and they become very effective. And another one of the things I think would be a good move for districts to make is to adopt a set of standard tools that can be used as a default set. And there are so many benefits that flow from that. Not only do attorneys get to learn one thing knowing they're going to use it the next time, but costs begin to go down when you have volume, contracts that go to the vendor. They become more familiar with how you want things done, so they do things quicker. All sorts of good things happen when you're in this transition period and you're able to identify a standard that everybody can work toward. But the online systems are immensely valuable. We did a mortgage fraud case a few years ago that was the largest, from what I was told by the government, it was one of the largest mortgage fraud cases at the time. We had over 400 real estate transactions. Each of the individual buyers, who was sort of their own little scheme, had 3 to 8 transactions, all of which became material and relevant when those witnesses were called to the stand. And we were able to create a database and an online repository that allowed us to very quickly and very easily sort the documents in a way so that each buyer's transactions would come up in a nice little group. We could split them down even further to specific pieces of property, and we could look within each file very, very quickly. Things that would have taken days and weeks of human time, we were able to do in minutes and hours. And it was enormously efficient, enormously effective, and in fact, it was so effective that when we went to trial, I didn't take any paper to court with me, unless I was going to examine a witness that day, and I had to have a piece of paper that I needed to hand to the court as the exhibit to stamp. But the whole trial was conducted with us having access through the court's Wi-Fi system to our online database, to the documents we anticipated to use as evidence being on a computer for an evidence presentation system. And all we did the whole trial was just say, would you show Bates number such and such? And when we needed to, at the spur of the moment, locate something that we didn't anticipate needing for cross-examination, we just found it in the database very, very quickly. We had it printed out if we needed to, or we just gave the guy who was doing our presentation the Bates number, and then we walked up and we did the cross-examination. I didn't carry a single binder.
If I could just jump in, Doug, so that's the optimal, right? Keep in mind, our challenges are, one, a lot of our data doesn't play well in these kinds of systems. Part of the reason why we are lucky to have a lot of CSAs who have strong skills in computer forensics, because we have to deal with a lot of data. And the data we're dealing with often doesn't play well with that, and we're still waiting for the industry to catch up in some way with the kinds of things that we need. So it is good, but I want to just highlight, it's not where the industry's not quite where we need it to be.
All right, I'm going to pass to Judge Gerard.
Yeah, let me tell you about the 3-week bank fraud case that I just finished 5 months ago, and I had 20 binders full next to me in trying that case. So where were you then, Mr. But to close that, seriously, to close that gap and maybe to even the playing field, I do want to go back a little bit to those cases, other than the 60 cases that are assigned to CDAs. What is being done or what can be done to provide direct assistance. And I would, both to you, Mr. Broderick, and to Mr. Mitchell, too, as a private practitioner, both to provide direct assistance, which you can do by phone and other ways, but to provide ancillary services and what I would call maybe the medium complexity bank or wire fraud case, or the multi-defendant drug case that isn't the mega case that gets there. So.
Well, and I'd say that's the defender offices are critical in that role, and often are the ones who take the lead in those kinds of cases. And part of the strategy has been working with defender offices who have staff who are comfortable with that, and I could turn it over to Ms. Elm to talk about further, but I'll say that is a linchpin to the process.
One of the things that defender offices across the country do is in the multi-defendant cases, we often take one of the defendants, and then, of course, CJA take the rest. But as long as we don't have a conflict, then usually the defenders, either through the defense kind of agreement, or maybe the court will suggest that we take a lead in organizing the discovery. We have on staff, of course, litigation support personnel, paralegals, IT people with forensic capabilities. We are better funded, and a lot of times we will take the lead either by being appointed to it or just voluntarily. That has been very helpful in bringing along our CJA so they can learn from it and work with us in it. And then often they can jump on some of the contracts that Mr. Broderick's office has, some national contracts for software, and we can start bringing them in. It has been a good way to try and make some of the transition.
To echo some of the things Donna said, I think one of the things that can be done and should be done is for those defendants who are the most culpable, that an attorney who has the skill sets necessary to handle large volumes of electronic discovery, and as well as the trial skills, be appointed to represent that defendant. There are, at least in my experience, and growing up much the same way, Judge Goldberg, with somebody just sort of throwing it at me and showing me and teaching me. I started out when I was a young lawyer being on a case with better lawyers, and the better lawyers would kind of teach me and show me, sometimes through osmosis. And I think that's probably one of the most important things. The other thing that I think is important in some kinds of cases is to involve experts very early in the process. There are certain kinds of fraud that take place, for instance, within an industry, and there's a file structure sometimes within that industry. There are keywords and phrases. There are patterns of fraud, and in other kinds of criminal conduct. There are patterns of behavior, red flags to look for, and I think very often if you bring in an expert in the industry to help teach and train the lawyers who understand the law but may not know how to recognize red flags, you can increase the effectiveness of those attorneys when they figure out what the red flags are and they start seeing the patterns easier. And then the other thing we have done in big cases that I've been involved in is we've had a series of practice sessions. When the discovery comes in and it becomes available online and people can start reviewing it, we teach them. And then we come back a while later and we hold shorter sessions where people can ask questions and they get little tips and tricks. And then over the course of the case, they develop a familiarity with the evidence, with how to use it, how to search for it, and they become generally just more effective.
All right, very good. Probably the last thing I would say, and I would echo Ruben earlier, that I think it's really important to assess the technological needs right now. I know it was done before, but where we're at right now with CJA lawyers, and then to develop a plan to educate and assist in a layered way that that you were talking about. And I'd be very surprised if one of our recommendations wasn't along those lines. So thank you. We'd encourage you to do so. Okay, that's all.
Well, you probably feel like you've been asked every question you could be asked by now. I wanted to talk a little bit about training, Mr. Broderick, and I know that you have a very small staff, but one of the things that we've heard around the country just for training in general for CJA attorneys is that there are these national programs that are offered, and sometimes in most districts also the federal defender offers a program. But for something this this specific, I don't think all federal defender offices have the ability to offer this kind of training. It's not the same as cross-examination training or something similar. Have you considered, and I know you're short on staff, but have you considered going to district by district and trying to train the panels?
Yes, and actually, that has been very helpful. So, for example, just last week, one of my colleagues and I were just working in Indiana Southern in Indianapolis, and we specifically worked with that office. In Arizona, we went to, and it's a good example, we went to Tucson and Phoenix, specifically designed just for the panel attorneys, because we also find that training with defender offices who have an infrastructure, they have resources, they have a structure, they have an information management system already in place. With them, for the panel, we specifically designed it just for the panel. And our program, the national program we do, the Techniques in Electronic Case Management, our assumption is actually to assume that it's a CJA panel attorney, and it's fine for defender officers to come to that. So we have put that, we do, I think, about 6 to 8 trainings similar to that for the defenders and for the panel. It's something that actually we think is very important to do. The challenge can be is that with the panel, you got to have a fair amount of faculty. And you got to have a lot of support, because people are, one advantage with the defender offices, you know, is like you can say, this is the type of computer you have, this is the kind of structure you have. With the panel, they come in, you know, and people, you know, a percentage of people will have Macs. Some people come in with, you know, Windows 98. And we're like, okay, might have to get a new computer here. But we actually enjoy doing that, and I think you're right that is something that would be, we want to do more of that and figure out ways to work with the defender offices to keep that going, because I know certain defender offices have started a similar process for their panel.
Well, let me ask you about that. And I heard Ms. Elm talking about IT services in some defender offices, but for the most part, those are bigger offices. The smaller offices usually have one IT person.
Right.
They don't have paralegals to assist the IT person often. And that person has to not only be the support person for the entire office,
Yes.
up to 20, 25 people, but also do all the case-related work.
Yes.
And so when Ms. Elm was talking earlier about how they're hiring a couple more IT folks in her office, and that would be a great thing for, I think, most of the federal defender offices to do. But now with the work measurement formula, I think you may have been hearing or will hear that folks can't do that because they don't, those IT people, those paralegals don't generate any caseload or cases,
Right.
weighted cases. And if they don't generate weighted cases, it's very difficult to hire them. So I mean, I think that we need to do a lot for the panel, obviously, in this situation, because it's worrisome just how far behind they are. But I also think the federal defenders have fallen far behind also. And with the new work measurement formula, I don't see us catching up. Have you had any concerns or any discussions regarding that?
Well, I know a number of offices have been looking towards sort of creative ways of dealing with these issues, which I think makes a lot of sense. And I believe that this is something that, you know, now it needs to go through the work measurement program, and it should be. And I think unfortunately, you're right, as I understand it, you don't get any points to that as far as getting additional staff. So it's something I think that the advisory groups are going to, I suggest that advisory groups take this on and think about that, because if we're going to get, you know, we're going to close the gap with the disparity with the Department of Justice, we are going to have to do more.
And obviously, the hope is that the defender offices will be able to also assist the CJA folks.
Yes.
But if the defender offices don't have the personnel, they're not going to be able to do it either.
No, and the CSAs and the paralegals investigators often, just like everybody else, are quite busy and are doing a lot of work already.
I just want to ask you one other question about coordinating discovery attorneys. I know that, or at least I think I remember correctly, that your budget comes out of the Defender Services training budget.
Training division, that's correct.
And is that how Defender Services, discovery coordinating attorneys are also paid? Out of your budget, which is out of that budget?
I now have to, it's actually it's within the Defender Services office budget right now. So it's separate from our specific budget, but it is a specific contracts that are with the Defender Services office through a community defender office.
So when Mr. Aoki, when you go into a district, you don't bill at all for the case, for the actual case from the court?
Correct. What I would be petitioning the court for would be outside services. So if we use a database company or a technology company, for example, the sortable spreadsheets we've been talking about for the wiretaps, I would petition the court for those funds, but not for my staff. And we do try to do as much as we can in-house.
I just want one more question for Mr. Aoki. Mr. Aoki, now I know how to say your name, I'm going to keep saying it. I wanted to ask you a question about the case budgeting attorney. It seems to me that the judges tend to trust their case budgeting attorneys. And so my question to you is that something you always do? Do you always go through them? I know you indicated that you would sometimes, or you would tell them what you were doing, but do you show your, kind of your contracts to them before they get processed with the court?
When I submit the funding request to the district court, I will also give a copy to the case budgeting attorney, in understanding that the district court may be asking them, what do you think of this? And I think out of courtesy to them, I want to give them a head start to look at it so they're not caught, just on a cold call. So I do try to make that my practice.
Thank you.
Paul.
These monster or mega cases you're talking about that are creating headaches for defense counsel are the creations of the government, because the government decides what to indict and who to indict and how to indict them. Is there something that we should be recommending to Congress by way of legislation or to the Criminal Rules Committee or to judges themselves in reference to the discovery being provided by the government and the way it's provided that would provide assistance to defense counsel in reviewing that discovery and therefore have an impact on the cost?
I'll let you go first.
That's a great question, and I'm hesitating because there's just so many levels to this. Yeah. It could start with something as, if they have it, can they give us investigative reports first? So we can make an assessment, the lawyers can make the assessment of the case. Can we get the 302s and the search warrant pleadings first instead of the hard drive of the receptionist that worked at the company? It also goes to the ESI protocols, great protocols, but they seem to stop at the U.S. Attorney's Office. They need to go extend all the way out to the agents, because how many times do we hear from the U.S. Attorney's Office, well, that's the way we got it from the agent. Well, but the protocol says, and so we now we're looking at converting formats, breaking huge PDFs down into individual documents, re-OCRing them, make them searchable, and there's just very many levels to it. And then you have drug cases where they're using local law enforcement. And now we're getting photocopies that are scanned, and the image quality to be able to search that is pretty poor. And now we're talking about, to overcome that, hiring reviewers to do objective coding.
It would be helpful to me, at least, and maybe to the rest of the committee, if we got those recommendations from you of the things that we should be proposing be done by the government in order to make the job of discovery easier and therefore obviously impact on the cost.
I'll be a little bit of an outlier here, but I understand the concerns, and they're large ones and they're significant ones, but it's a tough balance to strike, because we're dealing in an adversarial system that says the prosecutor has to look through the haystack and prove its case. And then in some respects, it requires the defense to look through the haystack with an entirely different lens to find different needles that will help them prove their case. And in some respects, there is some danger in shifting too much of the organizational and identification responsibilities over to the government and take away from the defendants that obligation and need to do the sifting and sorting and analysis. It's a hard thing, because if the government does too much of it, there's a tendency for the defendants to start looking at the case through the government's eyes. And they see the government's perspective, but they don't take the time to look at it from the defendant's perspective and then see the defendant's case. And in some respects, at least for me, just personally, the more important thing is to find a way to raise the defense attorney's capacity to handle these kinds of cases so they can do as easily with the haystack as the government does. Because the government's got to go through it, and they've got to find their evidence. There's got to be a way to raise defense counsel's skill set to the point where they can do the same thing. And I think it's a hard balance, tough balance.
I have just kind of a different take on that question. It seems to me in cases I've seen more and more, the haystack shifts. In other words, the defense attorneys work really, really hard on all this evidence that they just got from the government, that they got from the government in discovery. And then 2 weeks before trial, there's a whole new haystack. How often, Mr. Broderick and Mr. Aoki, do you see that? Because that really increases the costs of the case. And it seems to me I'm seeing that more and more from justice.
You can go.
Yeah, it's really very interesting because you're exactly right. The direction of the case, and there are jurisdictions that the philosophy is withhold certain documents or types of discovery until the very end. I was talking just a moment ago about distributing the investigative reports at the get-go. I'm dealing with a jurisdiction, we don't do that till the very end. I mean, they must go to trial a whole lot because if everybody's going to be looking at the investigative reports just a couple weeks before trial. And judges will ask me, from my experience, what really helps cut back on expenses, and that is getting people engaged in the case right away, setting deadlines. I think Judge Fisher has a wonderful order that gets people up and running in the first 45 days. Setting my own cases, I do a lot of white-collar criminal defense work. I'll go to the court and say, I'd like to have a preliminary list of exhibits, 3 or 4 months early, because that's how I'm going to target those hard drives of discovery, how I'm going to target, because I'm going to have to first try to figure out how this case is going to be prosecuted. In the same way as I want a preliminary list of witnesses as well, and with a reciprocal obligation. So what that does is helps refine my search. It keeps me from going from and I can see why lawyers are tempted to have that linear review because they're not sure where they're going to go with this case. But having the exhibits, witnesses, having a case schedule, getting everybody on board and making sure that last production isn't going to be like the Friday before I had a case, a Hells Angels case. I get 6,000 exhibits Friday. Trial starts Monday. And I had to put them in some sort of organized fashion.
And then we haven't even talked about sentencing where it can shift again on loss calculation and restitution, et cetera.
Exactly.
And so we understand.
All right. Well, I want to thank all of you for your time. Let me say a couple of things. First, that as a result of testifying here today, we've raised a lot of issues. I know there's been some follow-up requests from Mr. Kahn and from Judge Girard, but I also want to let all of you know that if we've stimulated some thoughts that you weren't aware we needed that information, please feel free to submit whatever you would like. This is a information gathering committee, and we really want whatever you have to give us so that we can review it, so feel free to do that. You can certainly contact our staff to get them that information. You can get on our website and get it. However you want to get it to us is fine, but we really would appreciate any follow-up. I want to thank all of you and for your time, and if we have any questions, we'll be sure to get back with you. So thank you.
Right. Thank you.
Thank you.
Get ready on the next panel.